Welcome to Talking Feds, a roundtable that brings together prominent former federal officials and special guests for a dynamic discussion of the most important political and legal topics of the day. I'm Harry Littman. From its initial focus on the most consequential federal prosecutorial activity, Talking Feds has come to sweep in the entire reach of American law, politics, and policy. But since January 6, 2021, our bread and butter has been a fine-grained prosecutors' tracking of the investigations, indictments, and civil and criminal trials of Donald Trump and his circle of sycophants and enablers. For most of that time, until quite recently, that focus left us with too much to cover in a given week, as the landscape of legal problems for Donald Trump was vast and varied. State, federal, civil, criminal, pre-presidency, during the presidency, post-presidency, just a stunning array of corrupt and ugly conduct. And all the cases combined to give robust hope of substantial, if not total, accountability, financial, legal, and political, for Trump's long list of misdeeds. Today, things look different. A series of disheartening assists in the legal system and a bizarre run of luck by the former president have gutted the country's prospects for full and genuine accountability, and even given Trump reason to think he can slip almost all the nooses. And in particular, his strategy of using the presidential campaign to escape his legal perils no longer looks as long shot as it did. Still, the criminal cases against him have been hobbled but not demolished. Each of them survives, and each of them still carries risks for Trump. And those risks, of course, plummet if the American people elect him, but that's always been the case. So with high campaign season having arrived, with the Republican convention, and with the Democrats besieged by doubt and uncertainty about Biden's position atop the ticket, we wanted to bring together some of the country's best-known analysts, really the mainstays of the cable coverage at MSNBC and CNN for these many years, and all good friends of the podcast, to canvass just where things stand with the various cases and what dangers they still present. And those friends are Norm Eisen, a senior fellow in governance studies at the Brookings Institute, a legal analyst for CNN, author of several books, and the founder and chair of the States United Democracy Center. Norm served as special counsel to the House Judiciary Committee, including for the first impeachment of President Trump, as U.S. ambassador to the Czech Republic from 2011 to 2014. His first book, highly recommended, is about that adventure, and worked in the White House as special counsel and special assistant to the president for ethics and government reform from 2009 to 2011. And he joins us from London, England, where he's given an important address. Thanks very much, Norm, for being here.
Thanks, Harry. Great to be back with you.
Kristy Greenberg is a legal analyst at MSNBC and former deputy chief of the criminal division for the U.S. Attorney's Office for the Southern District of New York. For some reason, we were joined at the hip during the recent Trump trial, and they put us forward to try to say something smarter too during the lunch breaks. At the SDNY, she supervised groundbreaking cryptocurrency and securities fraud cases, including the first ever cryptocurrency insider trading tipping scheme. Kristy, thanks for being here.
Thank you for having me.
And Joyce Vance, who may have been on the very first Talking Feds, but certainly from way back, an MSNBC columnist, NBC News and MSNBC legal analyst. She's a law professor at the University of Alabama School of Law, co-host of the Sisters-in-Law podcast, and a former U.S. attorney in the Northern District of Alabama. And I should add, having been a U.S. attorney myself, a long-time assistant U.S. attorney before that. Her Substack, terrific reading and really full of good stuff, kind of several times a week, is called Civil Discourse. Thanks very much, Joyce, for joining us.
It's great to be with you again, Harry. You're right. It was that very first episode. Yeah.
Okay. We have our 300th coming up soon.
Wow.
What?
Okay. Let's start with Judge Cannon, the dismissal? Is it a death blow, a mere flesh wound? How do we see things unfolding now? Actually, Joyce, maybe everyone knows Talking Feds, anyone says anything and interrupts, etc. But as an 11th Circuit specialist, I think you have a special vantage point. What happens now, and what are the prospects that this, in some ways, most powerful case against him will resurface?
Well, look, it's only a flesh wound, right? Because the worst case is the judge has said a special counsel can't file this case, but a U.S. attorney could refile it. I think, though, we'll see Jack Smith go through an appeal to the 11th Circuit. That has, among other advantages, the prospect, if the panel is the right panel, of having them order Judge Cannon recused from any further proceedings. And that would be a gold star here to go back to Miami, knowing that she will not be the judge in the future.
Let me push back on that a little and maybe bring in Norm and Kristy. Yes, by the terms of if we were playing by the rules set by Cannon, you just say, here, U.S. Attorney, you file this. But it's still a case against Trump. And Merrick Garland is still, very punctilious about, when else would you need a special counsel more than this? So for that reason, I wonder, even if it's legally kosher under her blueprint, if the department would be adverse to do it and really wants to stick with a special counsel kind of regime.
Yeah, I think that's what we'll see them try with the appeal, right? That would be the preference. Because I would not put it past Trump, who has complained vociferously about the special counsel, to then complain that it's a political witch hunt if DOJ proceeds with the case, which is why Merrick Garland went through this process in the first place.
I just will say, if Kristy will forgive me barging ahead, that we're not obligated just to view the decision through the legal lens, where it's absurdly unjustified from a precedential perspective. There's Supreme Court precedent, every other court to look at it. There's clear congressional statutes. It's not a close call. But we have to look at it in the context of Harry's I've never heard such a somber introduction to a Talking Feds on my many visits, and look at it also. Joyce quite properly starts with the law, but to look at it also through the political lens, because to drop this kind of totally lawless decision, I didn't think she could do worse than stopping the use of the seized documents from Mar-a-Lago during the pre-indictment investigation, but she's found a new low. But to do it in my best Talking Feds hysterical launch, to do it on the day of the Republican National Convention, it was like a nominating speech for Donald Trump. And we can no longer understand the opinions of American judges, including on the Supreme Court, through a legal lens. They've come unmoored with Dobbs, with the Chevron case, with the immunity case, and she took that and ran with it. This is not American law. This is what we expect from Orban's or Erdogan's courts or Putin's, not from an American judge, even such a shamelessly pro-Trump one. So for me, it represented one of the timing of it as much as the substance merited you do it with more gravitas, Harry, but it merited the alarm with which you kicked us off.
Well, not just kicked us. I called this from the start, the first Project 2025 opinion, where the governing principle is not law, but partisanship and loyalty to Donald Trump. But Kristy, let's zero in on the nuts and bolts a little more, if you know, and we can all sort of join in. So there is this recusal prospect, and there's this timing issue that Norm has just raised. I think it's not just that it was just before the convention, but there's an exquisite kind of timing here in that whatever political shot in the arm, and he right away trumpeted it, what Cannon had done. I think it's unlikely that the 11th Circuit reverses in time, so that the state of play come early November is that this one has been dismissed. And you saw now the call to unity, speaking of politics, of Donald Trump, to now let's all be unified and dismiss everything, Department of Justice. But what's both the timing and the kind of tactics and strategy of actually not just reversing, but trying to bounce her?
So, look, I think that we're at the stage now where, if they're successful in this appeal, that there is a pattern here where they could move to have her bounced from the case. In all circumstances, I mean, not just when she, had the opinion before this case was indicted back in 2022, we know that she had that opinion where she appointed the special master to oversee the review of classified documents seized from Mar-a-Lago pursuant to a search warrant. The 11th Circuit slammed her then. And then she has this opinion, which is completely lawless, about the appointment and funding of the special counsel. If you've got these two opinions from the 11th Circuit overturning her, and then I think the special counsel also needs to focus on some of the other opinions that she had, or non-opinions, as it were, that she has addressed. Her statements on her order regarding vagueness, where Trump had moved to dismiss the indictment on the grounds that certain phrases like unauthorized possession and relating to national defense are vague, which of course they're not. And Judge Cannon, even though she said she's reserving that order and she's kicking the can down the road on jury instructions there because she said that the terms are still fluctuating, I think that is another issue where the 11th Circuit can look and say the terms are not fluctuating. The statute is very clear about what it prohibits. It was clear to Donald Trump. And this is yet another example where she has gotten it wrong. I think those draft jury instructions that rested on that faulty premise of whether or not Donald Trump's designation of records as personal or presidential in any way affected whether he was authorized under the Espionage Act to possess classified documents. Again, a red herring, something that any law student would look at and should know. The Presidential Records Act says nothing about whether or not one would be authorized under the Espionage Act to have classified documents. This is another area where, again, her faulty premise has just gotten it wrong. And that was an example where Jack Smith had said, look, we need you to decide this now and promptly, well in advance of trial, because we need to be able to go to the 11th Circuit because we think this is so wrong before jeopardy attaches. And what did the judge say? She said no. And she said, look, you can do whatever you want with the 11th Circuit, but I'm declining to have any kind of, this would be unjust for me to finalize the jury instructions at this time. And she kind of tried to turn it around and backpedal a little bit, saying these were just draft instructions. She's just raising questions. But again, the fundamental premise shows she doesn't understand the law.
Yeah, and even if I could do it, I mean, even if she had this very definitive 93-page dismissal, she had 9 motions that she hadn't decided. Maybe that's enough for her for now, but let me just ask, they have now, the DOJ, in very quick fashion, approved the appeal and now filed the notice of appeal. But in terms of timing, it does seem to me that means it plays out after the election, and of course, if Trump wins, it's over. Does everyone agree? Is there any dissent to Joyce's view that now that they're on that route, that's what they're going to do? They're not going to either alternatively try to file anywhere else. They are committed to the canon 11th Circuit road. All agree?
Yes, tragically.
I have a slight addition to it.
Yeah, go ahead.
So I really am interested in whether or not, in addition to this appeal in the 11th Circuit, whether or not they would consider bringing a separate case of unauthorized transmission of classified information in New Jersey. If you'll remember, there is a section of the indictment with 2 examples in which Donald Trump shared that in private meetings, classified information with those who did not have security clearance. That is not charged in Florida. There wouldn't be venue, it would seem, for those charges in Florida. They are separate. They're so separate, in fact, that Judge Cannon said we have to strike some of this language from the indictment because it's not related to a charged conduct. It seems to me there's nothing that would stop the special counsel from appealing in in the 11th Circuit while also bringing a separate case based on that very discrete conduct in New Jersey. And, the question whether or not it would be worth doing seems like it's actually pretty straightforward. You've got a recording of the encounter where he did it in Bedminster. You have witnesses. You have the actual document that he showed a planned military attack in Iran. And it's really serious conduct. Obviously, maintaining the classified information in Florida when he wasn't authorized to do so is serious, but certainly sharing that information is even more serious. So I think they should consider it. Obviously, we don't know the extent of the evidence they have, but just from reading the indictment, you've got a recording, you've got witnesses, and you've got the document. I really wonder whether or not they should consider charging that conduct in New Jersey.
And you still have Nauta and Oliveira. Sorry, go ahead.
Yeah, I've got a slightly different view of that. I'm actually not certain that they have all of the evidence that they would need to charge. Whether they actually have the document itself and can identify it has never been clear to me. But even as they do, I think you have to consider as a prosecutor whether you're treating Donald Trump like you would any other defendant. Oh, the rich irony there. Nonetheless, you must play by Justice Department rules. And I'm not sure that if this were any other case, let's just imagine if it was a drug case or a public corruption case, and I had charged my primary case in one district and I had a little piece of conduct in another district. I'm not sure that I would go ahead and charge that. It looks a little bit petty and overdone. And so I would have to think long and hard before I did it. I think you make a good point, Kristy. This case is not like any other case. Judge Cannon disallowed this conduct, right, which the government had superseded and put into the indictment. And she struck it and said, hey, it's not this case. So maybe you do say, okay, well, since Judge Cannon says this isn't this case, we'll go ahead and indict elsewhere. But you cannot prosecute Trump by violating the rules and the practices of the Justice Department. And in this bizarre, ironic way, you have to double down on the principles and the rules we use when you decide when and where to indict him.
That's what they're going to write on the tombstone of democracy.
Joyce
and I have had a long-running debate. And I'm sorry, I'm usually the ethics nerd talking about the multiple strikes and you're out rule in the 11th Circuit, which Joyce helped create in a case she litigated there. But we've had a debate Joyce and I had a long-running debate on whether venue lay. I wouldn't have done New Jersey because it's too ancillary. It's the tail that wagged the dog under any circumstance. You could have done DC. There would have been a fight about it. Pre-Smith, pre-USB. Well, that's the face you made at me 2 years ago, Joyce, and you were wrong then, and now history accuses you.
No offense, Norm, but I'm pretty sure I was right. I think had there been jurisdiction in the District of Columbia, this case would have been indicted there. And they did not indict because this is a case about reckless mishandling. It's not about the original theft. And there must be some, flaw. I mean, we don't know what their evidence is. It seems to me that they can't prove Trump's taking it away. And by the way, my good friend Norm Eisen, we now have this bizarre presidential immunity ruling, which I think had this case been indicted in D.C., Trump might now knock the whole thing out as acts that were
it would not be any.
All right, my good friends, fast forward to the present. Look, it's all true. The venue thing, and that's
we
still
can't debate venue, Harry. We can't have a 15-minute debate about the law of venue before USB Smith.
No.
But I'll just say we all saw it then, and there are still a lot of people. The generally very solid tenure of Smith has that as, an asterisk. Should that indictment have been there? Did they want to run the risk and of 1 to 4, 1 to 5, whatever it was? Oh my God, Judge Cannon. Let's shift somewhere else where at least 3 of us were shoulder to shoulder. Justice Juan Merchan. So let me go to you on this first, Norm. We have the timing question as well. So he's convicted. He's made motions under this incredibly broad immunity ruling to get a new trial. Merchan is going to hear them, but is set sentencing for 9/18. What is the prospect that sentence will not be pronounced before November in this case? You're shaking your head, so explain it. Listeners
It's a
can't hear
limited
you.
prospect. It's a limited prospect. The laydown where Harry and I were in court together most days, the laydown, and Kristy, you were there some days too, right?
Yes.
In the
Mhm.
courthouse. I saw Kristy there. I, having, like y'all sat through it, that case is going to be very likely sentenced in September for the following reason. Whatever you think of the Supreme Court opinion, the benefit my friend John Roberts got for selling his soul to the majority was writing the opinion and creating an exception for unofficial acts. This is a case about Trump's conduct, election interference conduct before he got in the White House, and his private and business document falsification to cover up that 2016 election interference. There was some evidence that tangentially related to his time in office, but it was about unofficial stuff, like a reminiscence conversation with Hope Hicks about the campaign, how good it is that this information didn't come out that Trump hid during the campaign, conversation about Michael Cohen, who had no official government role. It's not enough, particularly because Trump he blew multiple deadlines. He abandoned a federal appeal on immunity. There's both a waiver and a substantive grounds. There's also a harmless error argument, belts, suspenders, and duct tape. The harmless error is probably the weakest of the three arguments. But at any rate, Mershon is not going to order a new trial. We know judges, when they invest their heart and soul, all of us as trial lawyers know, when they invest their heart and soul, they don't like that. The jury, they don't want to hold a new trial. Mershon's not going to hold a new trial. And Trump is going to get sentenced, I think, possibly to a sentence of imprisonment before the election. He won't serve it, but he will get the sentence, maybe.
Let me just serve up the timing question. Let's assume that's right. I think it is probably right that Mershon doesn't give him a new trial, and he continues to have the sentencing calendar for September 18th. Does Trump have a move at that point? By move, I mean a successful move to yank the ruling of no new trial up to the appellate division or even higher in New York in a way that keeps the sentencing at bay, keeps him from hearing in America, hearing the words, "You are hereby sentenced to blank." Any thoughts on that?
So, I tend to think no. The judge has a lot of discretion here. I think he will go ahead and sentence and then let Trump take his appeal after that. He has in some cases been, I think, appropriately so, deferential to Trump's rights. But here I think he's out of luck. He's been convicted. Unless there's a finding that he's entitled to a new trial, all that's left is for the judge to sentence.
No, but what if there's a finding that he's not entitled to a new trial? Does he have any chance at being immunity-based claim to yank it up? And that's the question, yeah.
Yeah, so that's an interesting question, right? Because the theory behind immunity is always that if you're immune, you shouldn't be subject to any proceedings, that would violate the immunity, so you get to take these preemptive appeals. And I suppose he could try to craft that sort of a proceeding in that situation. I think we've already seen the New York courts show a little bit of hostility towards that. I don't think it would work.
And it's too late anyway, right? He has been. Does Trump have any serious play to keep September 18th from happening?
I don't think so. I think the only way that would happen is if the appellate court really did think that there was some use of official acts evidence that presented a structural error under the Constitution that tainted this trial. But I don't see that here. Structural errors being things that would always result in fundamental fairness, things like denial of counsel at trial or some racial bias or failure to give a proper instruction to a jury. That's not the case here. I actually think that whether or not there's an official act on some of these, with some of the evidence that came in, maybe there is a question. I think it really depends on how expansively you look at what an official act is, which is what is so hard, I think, about applying the Supreme Court's decision. But I do think that even if some of this was an official act, I really do think that harmless error analysis really saves the case. There's so many examples in the record where even if the evidence that Trump is identifying as official acts were to come out of the record, there is more than sufficient evidence, overwhelming other evidence that proves the same point. I think back to, one example when they talked about that reimbursement form, where there was an admission from Trump that when he was president, that Cohen was being reimbursed. That was a really important piece of evidence. And yes, that form arguably, even though it's in the public record, let's say it was an official act. But we also heard, for example, from Stormy Daniels testifying that Trump personally sued her. And in that lawsuit said that there were reimbursements to Michael Cohen. So there are so many examples like that. Pretty much every example that he has, there's some other piece of evidence where you get the same point in the record. So I really don't see that he has any great arguments for this to be overturned, and I don't think that the appellate court would view this as such a structural error, being so fundamentally unfair that they would take it up before sentencing.
Fair enough. I'll just add quickly. Hope Hicks's main thrust of her testimony was how freaked out everybody was in the aftermath of Stormy Daniels. We had a lot of evidence on that point, though. And then second, I'll just say, appellate division says no. Court of Appeals in New York says no. There will be some, shadow docket motion to the U.S. Supreme Court, his good buddies. All right, but that's that. Let's take, before moving to the January 6th case that we are also focused on, what, if anything, is there to say about Fulton County and its prospects for the eggs being, unscrambled sometime in the 21st century?
Bleak.
I
mean, it's so extraordinary. If it weren't for the stakes for our democracy, if I didn't believe so firmly that the issue in the Fulton County and the D.C. Jack Smith case, the election interference of 2016 that he was convicted of covering up on steroids, augured the autocratic future of what Donald Trump will try as president, I would have to appreciate the fate of these four cases as a kind of Dickensian, like bleaker house. Bleak house isn't enough.
Spoken like the temporary Anglophile you are.
Good point. But you can't, because the stakes are so high, you can't have that sort of narrative amazement. I mean, he is the luckiest.
Unbelievable.
I just that Fani Willis, that case, that Fani Willis chose to have that affair with Nathan Wade. It boggles the mind. And
Norm or anyone, are you saying they're gonna have recuse her, the appeals court in Georgia?
No.
Or just even if they let it go, it's never going to be able to put the pieces back together again? Joyce, you had a thought. I'm sorry, I interrupted you.
I was just going to make the timeline thought that this case goes to oral argument in December. It's a 3-judge panel. Under Georgia rules, they do not have to issue their decision until March of 2025. Maybe they'll emulate the 11th Circuit and act in a speedy fashion, but I think that that's unlikely. And so this case is either an also ran because the federal prosecutions are back underway, or it just, dies a death because he's in the White House.
Yeah. Oh, and on that, by the way, this is not part of the subject of the podcast, but does everyone agree that at least the way the Supreme Court tried to frame the immunity opinion, it casts a very, very deep shadow on the state prosecutions as well?
Yeah, agree with that. Agree.
We got 3 yeses there. Yeah. All right. See why I was so cheerful up front, Norm? Okay, but let's go to I always have this postscript that among his incredible good fortune is not just to draw Cannon, I think randomly, but to draw her on the case that was least subject to arguments about politics and free speech, where it's just like red-handed in the cookie jar, and such a strong case that's the one that she was able to gum to death. It's a shame. All right, but now I think the one that it seems most to all of us, correct, please chime in if not, consequential, kind of important, sort of front and center, what makes him such a historically wicked president. The January 6th case, which is the very case, as everyone knows, that the Supreme Court issued the immunity opinion in. I think it's already Kristy who mentioned somehow, among so many other things, it's very confusing. So it's going to come back next month. Let me just serve it up there. I've left a pretty good chunk of time just for us to mull over and speculate. It's all we can do. But one thing to point out is the Supreme Court always going to be in the background here. Maybe that'll even affect the D.C. Circuit. But what do you see happening? What do you think Smith is thinking? What do you think Trump is thinking? Maybe what is Chutkan thinking? Let's just zero in for a good chunk of time on this one.
So there have been all sort of interesting and unusual ideas circulating about what Smith might do on the remand. I think based on what we know about him, though, he's fairly conservative, plays it close to the vest, has extraordinary appellate advice from Michael Dreeben, the former Deputy Solicitor General. I don't think we're going to see him suddenly drop a big new indictment with lots of additional defendants and additional charges designed to get around the immunity ruling. I think instead, he'll look at what he already has, decide what he can proceed with, where can he make a good faith argument that it's either within that sort of mid-range official acts where he can show that he can overcome the presumption of immunity, or where is it clearly the acts of Trump as an individual, candidate Trump versus President Trump. And he'll go forward from that point of view. Look, every prosecutor, Kristy will tell you this, you know this, Harry, we've all had courts say that we can't use evidence, and we've all believed that they were wrong to say that. And then we pick up the pieces and move forward. That's our job. I think that's what we'll see this team do here.
I think this fall, we are going to hear a lot of this evidence. The one thing that the Supreme Court said over and over again, and really sort of lambasted, I think, Judge Chutkan for, is the absence of a factual record in order to make these determinations of what acts are official versus unofficial. Donald Trump does not want you to hear that evidence before the election. There's been great public reporting by Hugo Lowell about his team's plans to try and block any hearings before the election. But I expect that we will have some hearings on this before the election. The Supreme Court was very clear to Judge Chutkan in the directive, you need to get to the facts. She has never been a judge to sit on her hands. So I think once she gets this case back to her, she is going to set a schedule for briefing, I think, as soon as this, late this summer. And I think we'll see these kind of mini trials in the fall. And as Judge Chutkan has to go through the indictment and make these determinations, whether certain acts are official versus unofficial, where they're official, do they overcome the presumptive immunity? I do think that it's worth considering the fact that the DC Circuit, in its opinion, they essentially said, look, we don't have to go through and do this analysis because we've determined that President Trump is not entitled to categorical immunity for his official acts. But they also said, we think it's doubtful that all 5 types of conduct alleged in this indictment constitute official acts. And they specifically point to, in the DC opinion, and again, this is not binding, but this was just, an aside, that the president has no official role in the certification of the Electoral College vote. And that a lot of these acts that are in this indictment, you could really see that he was acting as an office seeker, not an office holder. And again, we saw, I think, some of that even in Justice Barrett's concurrence, where she pointed to the slate of fake electors and said, this is plainly personal conduct. So I think as Judge Chutkan goes through this analysis, yes, we know certain parts of that indictment, particularly the section about DOJ and conversations that Donald Trump had with DOJ officials. We know that is not going to stay. But I think a lot of the rest of the indictment, I think a lot of it will still remain. And Judge Chutkan will do a very thorough analysis. And I think, we'll see that go back up to the Supreme Court, but she's going to dot her I's and cross her T's, get the facts from the witnesses. I don't think Donald Trump's team will be successful in trying to just argue this on the law. These are fact determinations. She's going to get to the bottom of it.
Well, I'm glad Kristy went first because she said everything I was going to say, and she said it better. I think he will try to cut it off, as we've heard some press reports. It's clear, though, that the Supreme Court has authorized judicial fact-finding because judges in the first instance decide. One thing to say an official act can't go before a jury. Judge has to decide if it's official or not. And if he tries rapid appeals, I think he'll be slapped down rapidly. And we will get a mini trial of the parameters of the case before the election. There's pins and needles about the electoral laydown. That mini trial could be a very important opportunity for the American people to consider the continuation of this pattern of election interference. We covered it up, 34 guilty counts in New York, continued on steroids in 2020. That will be an extremely salient stretch of time. If you want to get the flavor of what that mini trial is likely to look like, the Meadows and Clark removal effort involved a different legal predicate. It was under the federal removal statute, but the federal courts in the Northern District of Georgia had mini trials, took evidence, witnesses, made findings, and that's a preview of what to expect. And the courts echoed Kristy's point that campaigning is not official conduct, and neither is auto golpe, is self-coup. So a lot of the conduct is going to be ventilated and I think found by Judge Chutkan to be unofficial. And if this election turns back from a referendum on age versus autocracy to one on democracy versus dictatorship, that mini trial will be very politically salient as well.
Politics aside, there's something, Harry, that you and I have talked about before that I think may be interesting for listeners. That's the suggestion that DOJ does not take any steps that might influence the outcome of an election. And I think it's important to note here that prohibition applies during the investigative stage, pre-indictment. Once you've got a case in the works, and of course there are time constraints on prosecutors, you have to do stuff within a certain period of time, then I think DOJ is free to go forward. But I think we will hear the Trump folks raise this and argue that mini trials should not occur this close to the election, and they'll try to make hay out of DOJ's policy. We all know that DOJ is very careful in what's now called the Justice Manual, it used to be called the U.S. Attorney's Manual, to say that these are internal DOJ policies that don't create rights for defendants. Nonetheless, Trump is going to make that argument.
Yeah, I'll say as to that point, it's not even they can, they must. It's one thing to take investigative steps. A court sets a hearing, you can't not show up, and it is all about that. It's a subject. I'm glad you pointed out because it's a subject of, I think, great misunderstanding in the public, but it really doesn't have any purchase here. However, I am going to be the gloomy Gus through it out. There's two important points that have been raised. First is a mini trial could be important and pivotal, if we get back to what seemed more the landscape, say around New York, where it was really a judgment on Trump.
It was the landscape.
Was the landscape, agreed. And then, so although, part of the predicate question here is, did it have the sort of big effect? Because we know it was fabulously successful in a sense, but did it move the electorate? I wanted to get anyone else's sense on that, but then I am going to give the counterpoint, I'm sorry to say, on the evidentiary hearing. But let's just start here, though. Look, I'll make this is a devil's advocate argument. I don't really know how I feel about it, but closed proceeding, there's no TV again. You have a transcript where maybe Mike Pence says something, dramatic, but not arguably for us who were there, we thought the New York testimony was really, very illuminating, et cetera. Did it move the needle at all, especially with the people who needed to be moved? So that's the question.
Poll. Yes, it did, Harry.
Well, but Norm, isn't the case that after a couple? Well, go ahead. You've tracked this carefully. Go ahead.
This was at the time. I mean, I just can't believe.
And this is not a jury verdict, right? It will be a finding by a judge. Yeah.
I cannot believe how the world has turned upside down since we were there or covering it, the four of us. But
yeah,
what you saw, the assumption at the time of the New York case was that this would be an election decided like the past two were by less than 100,000 people in a handful, 3-5 states. And you saw a persistent 1 to 2 point polling swing that was it was not 1 or 2. It was any 1 or 2 can be dismissed. You saw after that verdict in poll after poll, dozens, you saw that persistent shift, and the landscape momentarily turned until June 27th.
Well, that's the question. Momentarily, was it? What did it not turn back before June 27th?
No, it did not. It absolutely did not. There was a small but persistent shift that would have stuck. Now, the world has turned upside down.
Yes.
Since then, and there are other issues that have come to dominate. It's now the age versus autocracy, but it could get back to dictatorship versus democracy in a variety of ways where those convictions are salient and a mini trial
and those
salient.
Mini trials are salient. Okay, so that's the question. All right. So now let me state a non-devil's advocate position. I do not believe, my best guess, I see the argument, I do not believe there will be evidentiary hearings. And that's and the point here is, including the political salience you're talking about, the evidence. Somebody's being on the stand, a Mike Pence or we can, Mark Meadows, there's many we can fill in the blank. So first, as to Kristy's point, I understand it's true that they think it's contextual, but in those critical 2 pages, they say allegations as much as they say, context or facts. In other words, I would more than argue. I feel pretty clearly it's at least left open that this must be done on the allegations, and that will be Trump's argument. It's not the same as saying it's not on the facts in a sense. But then second, with the breadth of their holding, the notion that they would be left to and the nature of their holding would be left to a district court judge just to decide based on what the sort of subjective factors and credibility findings that you normally do when they've given it such sort of constitutional moment, I think goes against the grain of the opinion. And then third, this whole problem is sort of a circularity as it comes to this very point of we call Mike Pence to the stand. Objection, Your Honor. They are about to give some official act. That's what it has to be. We've already said. In other words, Trump stands up and says, the very testimony that is contemplated is official action, and we know that from part of the Supreme Court opinion can't be proffered. Chutkan, I think, would be for it, but I think he immediately goes to the D.C. Circuit, which already sees the big 9 or 6 hovering over them, and then potentially the Supreme Court, and certainly enough to stall and say this is immunity. The eggs would be broken if you could have Mike Pence step forward and testify. We're not going to permit it at least before November. So there's my position, and it's not a devil's advocate position. So come back at me, or maybe all we can do is sort of surface it. But I'm not bullish. I wish, but I'm not bullish on the actual evidentiary hearing as opposed to a hearing on the allegations.
So I tend to agree with you, Harry, and I wonder if they won't use some of the language in the Supreme Court's opinion to argue that this should be a finding on the record that already exists, sort of looking at the allegations. As you say, I also think, Jack Smith inevitably has to argue that some of this is in the mushy public official acts category and that he's going to overcome it with a showing that it won't impinge on the presidency in order for there to be a prosecution. That is then a legal finding that Trump will take back up to the Supreme Court. It'll go up on Norm's shadow docket. That's probably good for another term's worth of delay. I mean, I wish that I was more optimistic about this. This is not my typical view of the courts, particularly as someone who spent part of her career as an appellate litigator. But I don't see anything good in the future here, I'm afraid.
And he only needs to get past November, right?
January. Smith has said he'll keep going.
Oh, that, by the way, that's a whole separate point maybe we should talk about. I think we've aired our different views, but wow, if Trump wins, are they really going to go pedal to the metal until January 20th, do you think? And what would that mean?
I would.
Yeah, so like give me an example of something they'll do, an aggressive move, knowing that Trump's going to be inaugurated on the 20th. I'm not disputing, but that's a politically breathtaking situation, right?
I don't think it's a political calculus. I think that this is a legal calculus. Much as Jack Smith, I've said is serious about his obligations, he's serious. And that means that he will continue to move forward until the day when his defendant is ineligible for further prosecution.
Let's swear a jury, Your Honor. I'm just talking concretely where, does this happen full bore, and any thoughts about what that period could look like? All right, let's now finally go back to Norm's point and paradigm, and it's every lesson seems to be it's up to the American people, but they come through. Trump loses, and so all of these things potentially could be revived, but we still have the immunity opinion. We still have the dismissal. To what degree is he better off in 4 or 5 months having lost than before before the world turned upside down? Do you see it as basically, now it's all going to be okay, or are things still like totally, as the Brits say, verkauft?
I think you're going to see sooner or later the Georgia case will roll, the D.C. federal case. I think Trump will lose on appeal and serve whatever sentence Merchan gives him, could or could not be incarceration or weekends or Lord knows what. And I think it's more likely than not that this is the last straw for Cannon. It's possible, I should say.
Yeah, I don't see her having the case again, one way or another. I think it's out of her clutches.
So that's all bad news for Trump. Not fast, but certainly before the Trump 2028 presidential campaign.
All right, so Talking Feds listeners, we did this on purpose. Some of this is academic now, but some of it is very practical. And, it's depending on what happens to the election, not going away. Even now, as all the focus and coverage will turn to the pageantry and insider fighting of the politics, these cases are there, and they are in some mid-range stage. So don't think they're gone. Donald Trump shouldn't think they're gone, and everybody should vote. Thank you so much, Norm, Kristy, and Joyce. And thank you very much, listeners, for tuning in to Talking Feds. If you like what you've heard, please tell a friend to subscribe to us on Apple Podcasts or wherever they get their podcasts. And please take a moment to rate and review this podcast. You can also subscribe to us on YouTube, where we are posting full episodes, talking books, and bonus video content. You can follow us on Twitter at Talking Feds Pod, and you can look to see our latest offerings on Patreon. Talking Feds is a completely independent production, so if you like the work we do and are inclined to support the show, joining our Patreon is the best way to do it. Thanks for tuning in, and don't worry, as long as you need answers, the feds will keep talking. Talking Feds is produced by Catherine Devine, associate producer Gabriella Glick, sound engineering by Matt McCardle. Rosie Don Griffin, Hamsa Mahendranathan, David Lieberman, and Emma Maynard are our contributing writers, and production assistants by Akshaj Turbailu and Anna Salvatore. Our music, as ever, is by the amazing Philip Glass. Talking Feds is a production of Delito LLC. I'm Harry Littman. Talk to you later.